Lori, whenever you're ready.
Okay, hi everybody. Welcome. We're so excited you're here. We might have a few more people joining us, but thank you for taking the time to join us this morning. If you don't know me, most of you do, I think. I recognize most names. I'm Lori Wheeler, president of the South Pasadena Chamber, and next to my right is Nicole Clark, who is the communications director for the chamber. And we work very closely with Dawn at the Small Business Development Center for a lot of different things. We refer businesses to them all the time. And I was very excited when he reached out to us and to Mary at the city to put this together for South Pasadena businesses. So without further ado, I'm just going to kick it back to you, Dawn, and let you take it away.
Thank you, Lori, and welcome everyone to this workshop. And yes, I want to echo that comment. We've been partners with the South Pass Chamber and the city going back several years, and we always enjoy participating in these. Now, the Small Business Development Center, the best way to describe what we do is to play a short video, and then I'll come back and introduce Shamara. So with that.
At America's Small Business Development Center, our mission is simple: to help businesses grow and succeed. At the SBDC, we offer no-cost consulting and low-cost training to make it easier for businesses to start, grow, and recover. As a valued resource partner of the SBA, the SBDC serves small business owners throughout the U.S. by providing timely expertise and advice that business owners can use today. These services are especially helpful for small businesses impacted by COVID-19. There are 9 SBDC locations in LA and Ventura counties, and one right here in Pasadena at Pasadena City College, where we offer one-to-one consulting with experts in SBA disaster loans, strategic planning, marketing, financial analysis, and many more vital services. For no-cost help with your small business, contact the PCC SBDC at 626-585-3105, SBDC at pasadena.edu, or pccsbdc.org. We are here to help, no cost and no catch.
So I'll leave that up for a second for y'all to screenshot it. And we will also put some information in the chat throughout as well. So again, there are several SBDCs in LA County. We are hosted by Pasadena City College, where we contract with 20 different advisors who are available to help you on workshops like this or one-to-one as well. And with that, let me introduce one of those amazing advisors. Shamara Palma is an HR expert, and she's going to share some information with you all related to some of the new rules and guidelines. And with that, Shamara, take it away.
Thank you, Don. Thank you for that introduction. Thank you, Lori, for having me again. It's a pleasure to be here with you all today for the 2023 new employment laws as they relate to small businesses. Keep in mind that these are not all the laws that went through in the state of California, all the employment laws, but these are the most relevant ones that apply to small business owners. And thank you, Don, for introducing the SBDC. With that, I will skip my introductory slide and introduce myself. I'm also a small business owner Myself, I have a consulting firm called Solve It HR, and I've been doing human resources for over 15 years now. In too deep to back away. I really quite enjoy my job. I enjoy helping business owners with anything employment related. So if you do have any questions about employer compliance, handling your human resources, managing employees, anything like that, I can assist, and feel free to reach out to the SBDC at pasadena.edu email, and they can pair you up with either myself or, as Dawn said, one of our many experts in any other areas of small business administration. Our agenda for today, what we're going to cover, I will cover laws that went through in regards to wage and hour, benefits, workplace safety, and some miscellaneous laws that went through. And at the end, we'll wrap it up with a Q&A session. But if you do have questions related to anything that I'm covering, feel free to drop those questions in the chat, and I'll be checking in with Annie, who's going to monitor the chat for any questions. A brief disclaimer before we get started. As many of you know, the nature of human resources is ever evolving, and the materials that I will cover today are updated as of today, February 21st, 2023. Anything that I do share is not intended to be considered legal advice or recommendations, but rather for informational purposes and best practices for employers. All right, let's dive right in. First up, I want to cover pay transparency law. I think this is the most impactful law for small businesses, and it actually comes in 3 different layers that apply to all employers with 15 or more employees, and those with 100 or more. At the first level that applies to all employers across the board is that it requires that employers provide the pay scale to their current employees upon request for the position that the employee currently holds. This is something that's new to everyone, and also to those with 15 or more. Another requirement that applies to all employers is that they have to maintain a record of job title and wage history for each employee for the duration of their employment, and an additional 3 years post their separation of employment with the company. This is not a new requirement, should not be a new requirement, because the law changed about 2 years ago, where employers now were required to keep records an additional 3 years. So this basically is aligning with that law. So this shouldn't really be new, but just as an FYI for everybody. And then the law does include a section that it includes a rebuttable presumption. And basically what that means is that should an employee file a claim against an employer alleging non-compliance for any reason, the court or the agency, the labor commissioner, is likely to favor the employee if the employer has no records to counter their claims. So that's why it's more important to keep those records and make sure that they are updated. And when you do switch, many employers who do switch payroll companies, they forget to transfer or retain those records from the previous company up to the new one. So that's something that you also want to keep in mind. Should you transfer or switch payroll companies, you want to retain that information. Now, the second layer that applies to employers with 15 or more employees, obviously, they also do have to disclose the pay scale to their current employees. But in addition to that, they have to disclose the pay scale on any job advertising and upon request from their current employees. If they engage a third-party agency that conducts the recruitment for them, they have to disclose that pay scale to that third party so that they can include it in the job ad. And the employee count, this is a question for many employers. What constitutes 15 employees? Do part-time employees count? Do full-time employees count? It's basically any pay period where an employer hits 15 employees on their payroll. So at that point, that's when the law will begin applying to them. One thing that the law excludes any information on bonuses, commissions, or additional tangible benefits. And that's not required to be included as part of the pay scale, but many employers still include it in their job posting anyway. But just know it's something that's not required. Penalties for non-compliance with this requirement range from $100 up to $10,000 for employers. So it really aligns actually with a lot of the penalties that are applicable to many of the other laws. We want to avoid that. And then the third layer to the law applies to employers with 100 or more employees. And basically this law amends it's kind of like a sequel or amends a previous law that went into effect in 2021, where it required employers to disclose their pay data information to the employment department. So basically, employers needed to submit a report outlining what the pay data was for each category. And now it's being amended to include additional information that was included in that report. And now it requires that employers disclose the mean and the median for each job category, broken down by race, ethnicity, and sex. And previously, the law used to align with the federal level law that also required employers with 100 or more employees to turn in a report. In the HR world, we know it as the EEO-1 report, the Equal Opportunity 1 report, that is submitted to the Equal Employment Opportunity Commission on an annual basis. But now that the requirements got extended to include additional information, this report can no longer satisfy the requirements of the state of California. So now it's an additional report that needs to be submitted to the California Civil Rights Department, previously known as the DFEH, as the Department of Fair Employment and Housing. They changed their name back in the summer last year. One thing to keep in mind is that employers that have multiple locations must also submit a separate report for each of those separate locations that they currently have. With the new year also comes a change with the minimum wage. Every January 1st of every year, we do see an increase on the state's minimum wage. Currently, the minimum wage increased to $15.50 an hour for all employers across the board. That is a hefty increase for the smaller employers that were used to just getting about a $50 a 50-cent increase for the minimum wage each year. So it used to be broken down by larger employers, those with 26 or more employees, and then the smaller employers, those with 25 or less employees. And there was about a 50-cent difference between the two. And now we saw a dollar jump for the smaller employers from $14.50 to the $15.50 that is applicable to everyone across the board. And this has to do, or is in response to the inflation rate we saw last year and we're still dealing with. Another thing to keep in mind when minimum wage increases is that also the minimum salary increases for all the employees that are paid as salary. So the minimum salary to be able to be in compliance with that is $64,480 as of January 1. And there's also a minimum monthly salary that needs to be paid out to those employees, which is $5,373.33 to be able to meet the criteria of classifying someone as a salary exempt employee. If you don't meet that criteria, then you need to classify that employee as an hourly employee, or you could also classify them as salary non-exempt, meaning that they are eligible for overtime and all the other wage and hour laws that protect most hourly employees. I will be checking in with Annie. I see maybe there's a question in the chat. Not sure.
Hi, Shamara. So far, we don't have any questions,
Okay,
so I think we can continue.
okay, perfect. Okay, and then there's also local ordinances that apply to employers. There's many that apply all throughout the state, in Northern California and all throughout the state. For Southern California, we have the cities of Malibu, West Hollywood, Los Angeles, Pasadena, Santa Monica, and unincorporated LA County that have minimum wage ordinances. And usually the local ordinances change every July 1st. So as of July 1st last year, these are the current minimum wages, also broken down by smaller and larger employers. Usually there tends to be a difference. And if you all recall, many years back, there was a law that passed that wanted to increase the minimum wage to $15 an hour for anyone by 2020. But now, due to inflation, we are seeing an increase over that $15 an hour. And employers do need to comply with those requirements if you have employees that conduct business in those city boundaries. So even if you don't have a physical location within the geographic boundaries of the cities, but you do have an employee that performs at least 2 hours of work within a work week, which is the requirement for most of the ordinances, you would need to pay them that applicable minimum wage for that time they spent working within those geographic boundaries. So say, for instance, you have an employee that goes and visits a client in city of Los Angeles and they spend 3 hours with that client, you will need to pay them the city of Los Angeles minimum wage for those 3 hours they perform work there. Another area where this is always a pretty hot topic, and the most contested area out of all the wage and hour regulations is the meal and rest period. Every other year we always see a litigation in regards to compliance with paying meal and rest periods. Last year was no exception. There was a lawsuit that alleged an employee was not clocking or was not being compensated correctly for their meal periods because the employer had a payroll system that rounded the times that the employees clocked back in from work. So for example, the requirement is that you have to provide an uninterrupted 30-minute meal period to the employees. But the payroll system, if an employee clocked back in, say at 27 minutes, it would round up to the 30 minutes. So it would look like they were in compliance when in fact they were not. So that's something to keep in mind. If you have or your payroll system rounds any meal periods or even any other times the employees are clocking, you want to make sure that you get that taken care of because this can lead, as we saw, to a litigation. We also had the courts change the premium pay rate for any missed meal periods. So the regulation is that when an employee is unable to take a meal period because of work prevented them to, or because they were not relieved from their job duties, they are entitled to 1 hour extra pay, which is considered premium pay. And that used to be calculated at the employee's base rate. So if you're paying somebody minimum wage, you would have paid them an extra hour at $15.50 for that missed meal period they had. Now, the court actually has changed that from a penalty to actually turning that premium pay into a wage, which implies now that you have to also include that on your wage statement for all employees in order to be in compliance, and all the other wage and hour laws would apply to that wage now, to that premium pay that's now a wage, including non-compliance for paying your wages on time, which can lead to a 30-day penalty at the employee's daily rate of pay. So that's something that also needs to be included within with your wage statements or your pay stubs, and make sure that your payroll company is in compliance with this, because this is something fairly new that went into effect. So bottom line, just want to make sure that you are in compliance with your meal periods. It's probably an area that everyone needs to audit all the time to prevent any potential claims or any potential lawsuits in that area. I said that is like the most contested area of a wage and hour lawsuit. Just keep that in mind. You don't want to see anybody ending up in a lawsuit or in a claim for that. We also did have protected bereavement time law go through, AB 1949, which applies to employers with at least 5 employees, and it grants up to 5 unpaid days for bereavement time after an employee has worked for an employer for at least 30 days. It also includes, defines the eligible family members for which an employee can take the bereavement time to be a spouse, child, parent, sibling, grandparent, grandchild, domestic partner, and parent-in-law, which those family members pretty much align with most of the other leave of absence laws that grant time for employees to take time to care for a family member. A few things or a few details of the law is that it must be taken within 3 months of the date of death. And if you already have a policy, and most employers would have a policy that compensates for 3 days of bereavement time, that's still okay. You just need to make sure that you update to be in compliance and include up to 5 days of time off. Obviously, the other 2 days are not going to be compensated, or unless you decide to compensate for all 5 days. And employees can use any available balances to get compensation for those 5 days. So they can use some vacation, paid time off, any sick time available, or any other time available to them to be able to get compensated for those days if you don't provide already provide bereavement pay. And there's also protection for discrimination, interference, and retaliation. And the bereavement days do not have to be taken consecutively, right? The employee has up to 90 days to be able to take that time. And you also can request documentation to verify an employee's need to take bereavement time within 30 days of them notifying you. But that documentation must be kept in strict confidentiality. So obviously only the person that maintains records would probably have access to that, making sure those records are also kept locked and not accessible to anyone within the workplace. And talking about leave of absences, we also did see an expansion to the eligible members for employees to be able to take leave under the California Family Rights Act, known as CFRA, and also under the Healthy Workplace, Healthy Families Act, aka that's the sick leave law. There's 2 definitions now. In addition to already the eligible family members, they can add a designated person to care for, to take time off from work to care for. A few differences between the definitions under each law. Under CFRA, it's defined as any individual related by blood or whose affiliation with the employee is the equivalent of a family relationship. And under paid sick leave, it's basically of any person identified by the employee at the time the employee requests sick days. So that can essentially be anybody, right? So many questions from employers are like, well, how are we gonna be able to manage the absences the employees take. One thing the law does provide is that you can actually limit it to one designated person per 12-month period. And that 12-month period should align with the 12-month period you use to calculate leave of absences for other purposes. So if you use a calendar year to designate leave of absences, then it will be a calendar year. It just needs to be consistent, but you can limit it to one designated family member. Annie, I'll check back in with you to see if we have any questions.
Yes, thank you, Jamara. So this is going back a couple slides. We have a question from Yvonne. Does that minimum pay for 2+ hours of work include transportation expense allowance?
Talking about the minimum wage ordinance.
Yeah, so like when you were talking about how if an employee is traveling to a client's place of, to perform work or service. So just in case, just say, 2+ hours of work, but they would be paid that minimum wage in that city. Does it include transportation expense allowance as well?
Yeah, you always want to pay for mileage and also the time the employee is taking to get to that location. So you would pay for mileage you can use the IRS's recommended rate, or you can use a different rate if you, for example, say you also compensate for gas, for fuel. You can actually pay a little lower than the IRS recommended rate, given that would kind of balance itself out. But you do need to pay for mileage, and you also need to pay for the time the employee is commuting to that location.
Okay. So we have a couple more questions regarding meal period and rest periods. Does uninterrupted meal period also include rest breaks?
Yes. Yes. So that's a very good question. Thank you for bringing it up. Yeah, so the rest breaks and the meal period should be uninterrupted. Now, sometimes I get questions from employers saying, well, I told my employee to go on lunch break, but they refused to, or they didn't want to. They just rather finish early. In those situations, you do not have to pay the premium pay because your job as the employer is to make sure you provide them the opportunity to take the meal period, not to really police that they do take it. So if you provided them the opportunity, you relinquished control over their job duties, over their time. They were free to go if they wanted to. They chose not to. There is no penalty. There's no premium pay that's owed to them there. You would just pay them for the time, right? If they're still working during that time. But the same applies for the rest breaks too. So if an employee is not able to be relieved from work, premium pay would be applicable to them. So potentially there could be 3 hours of premium pay if they miss all their breaks, their meal breaks and the rest breaks for the day. So yeah, that is applicable also to rest breaks.
Okay, I do have another question around that topic. What is the threshold for a required unpaid meal break versus a paid break time? So number of hours worked.
So the regulation requires that an employee be provided with an uninterrupted 30-minute meal period for every 5 hours worked. So if they're going to work more than 5 hours, then they should be taking a meal break prior to them hitting that 5th hour. So before the end of the 5th hour. Okay, so if somebody begins work at 8 a.m., they should be able to take their meal break no later than 12:59 p.m. at 1 o'clock, that is actually already not in compliance. That is the beginning of the 5th hour and not in compliance. So that is essentially when it is applicable. There is an exception, like if somebody is going to work only 6 hours, no more than 6 hours in a day, then you could, if the employee wants, actually, you don't ask them, but if the employee requests or if they want to waive their meal period, so they can leave earlier or for whatever reason, they can do so. But it should be in writing and it should be done every single time that they choose to waive a meal period, so that you can have proof that the employee actually requested that and it was not negligence on part of the employer to do so. So essentially, yeah, the meal breaks apply at every 5 hours work. So if someone's going to work 10 hours, then or over 10 hours, then they take another meal period before the 10th hour. I hope that answered the question.
All right, we have a couple more questions. And this is, I think, regarding CalSavers. When must this person be designated? I think you had mentioned needing to designate.
Yeah, so we're talking about the California Family Rights Act.
Okay.
Designated person. So they should designate it at the time they request to leave. So that's when you can ask them to, or they can tell you that they are designating someone, or they're going to be taking time off to care for someone. Yeah, for under the sick leave, they're going to notify you at the time that they are requesting, or they're calling out sick, right? I'm calling out sick because I'm taking care of, someone that's outside the family members list under California family, under California sick leave regulations. So they will notify you at the time that they're actually requesting the leave and requesting to designate a person. You wouldn't want to go asking everybody to like designate someone, right? Yeah, but say at the beginning of the year, like let's designate someone to take a leave of absence for, but they should notify you as soon as they know that they're going to be taking time off for them to care for them. All right,
Jamara, can we answer one more question since it's regarding bereavement before we move on?
Sure.
Do these regulations regarding bereavement apply to part-time employees as well, or are the requirements only for full-time employees?
All employees.
All employees. Okay, great. Thank you.
You're welcome. All right, so moving on, we have changes to CalSavers requirements. So by now, most employers, or at least those with 5 employees or more, should have already registered with CalSavers by June 30th of 2022. If you have not registered with them, I highly encourage you to. I've included the link here where you can go ahead and register. But CalSavers essentially is California's retirement savings program for employers who do not already provide a retirement plan. So if you do provide a retirement plan, you still do need to register to let them know that you are already in compliance and you're not on the radar for non-compliance and potential penalties. Penalties can range or can be $250 per employee as imposed by the Franchise Tax Board. If you receive notice from the Franchise Tax Board, you must register within 90 days, and failure to do so can cost an additional $500 per employee penalty. So bottom line, if you do have at least 5 employees, you should have already registered. If not, you can go ahead and register at calsavers.com. I've included the link there. But now the change to this law is that now it is expanding the law to apply to employers with at least one employee. So that excludes business owners, but you do have, if you have at least one employee, you do have until December 31st, 2025 to be able to register and be in compliance with this regulation. We did have SB 951 that actually made changes to the paid family leave and the state disability rate. That is something that's going to go into effect as of January 1, 2025. But the rate increases are going to be for state disability insurance. It's going to go up to 90% of an employee's wages for when an employee is out on disability. And also for those taking paid family leave benefits. For example, these benefits may apply if an employee is taking time off to care for a family member. Oftentimes it's taken by mothers or fathers taking care of their newborn child, or if they have adopted a child, they will take time off of baby bonding time to actually be able to be with their child, and they will get paid through the state up to 8 weeks for paid family leave. And currently the rate is about 65 to 70% of an employee's wages, but that is obviously going to change in 2025. Now there are grants, there is a program, there are grants for small businesses when employees go on leave to cover for that extra expense of having to train someone or having to have a temporary employee come and cover, or for job advertisements or anything like that. There is a grant. It's $2,000 for employers with 1 to 50 employees and $1,000 for those with 51 to 100 employees. And the employee count is applicable to those employees here in California. I know someone asked the question in the past if the employee count includes out-of-state employees, and unfortunately only applies for those employees here in California. Grant eligibility criteria that you must employ between 1 and 100 employees, be registered to do business in the state of California, be in an active status with the Office of the California Secretary of State, and have an active California employer account number under which employees are listed for payroll. So this would be like your EDD account number. The application period ends May 31st of 2024 until funds run out. And actually, there is a waiting list now for to be able to apply for the grant. Businesses that do have a PEO are not eligible. A PEO is a professional employer organization. So these are, for example, like the ADPs of the world that handle your payroll, your HR, your safety, workers' comp. Because of that co-employment relationship with PEOs, you would not be eligible to take advantage of this grant. Now, moving to workplace safety laws, we did see a few laws that went through. SB 1044, effective January 1st this year, basically prohibits employers from threatening or taking any adverse action against an employee for refusing to either report to work or to leave the workplace early if they have a reasonable belief that the workplace is unsafe. It also prohibits not allowing a worker to use their mobile device or any other communication device to get emergency assistance, to assess a situation safety, or communicate with someone to verify their safety. So basically, where this I can think of where this would be applicable would be like in an active shooting situation where an employee decides to leave, or an employee does not show up to work. And it also requires the employees notify their employer in advance if feasible, if not as soon as possible. Under the law, emergency condition is defined as one, either conditions of disaster or extreme peril to the safety of persons or property at the workplace caused by natural forces or a criminal act. So for example, the example I gave, like with the active shooting, would be something that would qualify under this. And then in order to evacuate a workplace, worksite, worker's home, or the school of a worker's child due to a natural forces or a criminal act. So those would be the two conditions or the two situations by which an employee could decide to either leave or not report to work, and an employer cannot take any adverse action against them. Now, one clarification the law makes is that it clarifies that a pandemic is not considered an emergency condition under the law. I can't even imagine if they would have included that. Nobody would be reporting to work. And one thing to keep in mind is that there are exemptions that apply, in particular in the healthcare industry and for disaster service workers, among a few other exemptions as well. We did also see changes to the COVID-19 regulations. We had AB 2693 that applies to COVID-19 notices. As many of you may be already familiar, for the last couple of years, employers were required to provide a notice within 1 day to employees of a positive COVID-19 in the workplace or exposure to COVID-19. Now this requirement has changed to an employer being in compliance if they post a notice in a conspicuous place, ideally where you have all your other employment notices and posters. And that notice needs to be in place for at least 15 days to satisfy the requirements. It must include the dates of infection period when the case was on site. And one good thing is that employers are no longer required to report cases to the local health department, right? And this notice requirement extends to January 1 of 2023. The original law was set to expire January 1 this year, but this law extends it another year and making the change of just being in compliance with the posting of a notice rather than actually issuing a notice to each employee that was exposed to COVID-19 in the workplace. Do we have any questions, Annie, in the chat?
Hi, Shamara. Yes, we have one from Yvonne. She wanted to know if care provider requirements are the same as VAWA provisions. Is it something that you can respond to?
No, I'm not.
I'm thinking that VAWA, remembering the full name, Violence Against Women Act, and I don't think that's the same, but the discussion about paid leave is relating to that. So that's so many acronyms in my head from so long ago. Sorry about that.
You know, maybe this is a question we can address at the end. I'm not quite sure right now how to address it, but maybe we can I can, if we're able to connect at the end to get more specifics as to the questions, I'd be more than happy to answer that or get back to you with a response. Any others, Annie?
That is it for now.
Okay. All right, so COVID-19 regulations, we do have finally an effective non-emergency temporary standard. So for the last 2+ years, we were dealing with Cal OSHA's emergency temporary standard, or ETS, and it made quite some requirements from employers, including exclusion pay, which meant that whenever you had a positive COVID-19 case in the workplace, you had to exclude it. Not only that, but you also had to compensate the employee for the time that they were out. So as you can imagine, when the pandemic was at full swing, This was quite a hit or quite a cost for small employers in particular, to have to compensate the employees for all the time that they were out, and especially if they had multiple people that were exposed to COVID-19, they also had to compensate for those. So good news is Cal OSHA actually has adopted a non-emergency temporary standard, which replaced the original emergency temporary standard. And now this regulation or this requirement actually becomes more embedded with the injury and illness prevention program, which is already a requirement of all employers with at least one employee. So making sure that it's sort of like a safety handbook, if you will, for making sure that employees are safe in the workplace. So this standard is being rolled into that injury and illness prevention plan. It no longer is required for employers to have a separate COVID-19 prevention plan as the original ETS had required it. The 2-year mark we're looking at for this non-emergency temporary standard is from February 3rd, 2023, which is when it was approved, to February 3rd of 2025. And again, it applies to all employers with at least one employee. And most of it, finally, thank God, aligns with the California Department of Public Health requirements. So for example, the face covering requirements are now being deferred to the California Department of Public Health requirements. So you would need to be checking when you do have situations where you do have COVID-19 cases or an outbreak, you would need to be referring to the California Department of Public Health requirements for employers to be consistent and to also be in compliance with the non-emergency temporary standard in your IIPPs. Employers are still required to report major outbreaks, employee death and serious illness to Cal OSHA, as it always has been. In the case of death or serious illness, it has to be reported within 8 hours to Cal OSHA in order to be in compliance. So some things that the ETS did not change is, for example, an employer is still required to investigate a COVID-19 case. You're still required to include dates of positive tests and symptoms on notices. Also, you must maintain effective policies and protocols to prevent the spread of COVID-19 and protect your workers. Again, this is referring to the new regulations now that are, or the new plan or update you may have to your illness and injury prevention program. That's where you want to include the protocols. Or if you used to have a COVID-19 prevention plan, you can still keep the plan. You don't have to. You can roll it into the IIPP, but if you choose to keep it separate, you can still keep that plan. Just make sure that it is updated with the new non-emergency temporary standard regulations. Close contact definition, that's still pretty much the same. It's defined as sharing indoor space for those workplaces with less than 400,000 cubic square feet. And then it's 6 feet of distancing for those with over 400,000 cubic square feet. And again, free testing must be also available for close contacts. If they are exposed to somebody with COVID-19 in the workplace, you must still provide the free testing. If an employee actually contracted COVID-19 somewhere where it's not the workplace, you're not required to actually provide the free testing for them at that point. But best practice, it probably is that you do still provide the free testing to everybody across the board. A few laws that went through in terms of related to discrimination. AB 2188, it actually protects an applicant based on their personal use of marijuana off the job and away from the workplace. So this law actually goes into effect next year on January 1, but essentially employers cannot discriminate against an applicant or even an employee these days for the use of marijuana off the job. A lot of times, when marijuana was legalized, this was quite a hot topic, but we are actually not able to know when an employee used marijuana in the workplace or where they did not. Employees, they may not possess marijuana or be impaired while on the job. So that is something that is included in the law, that it does provide that employees or applicants should not be violating an employer's drug policy to possess, be impaired, or use marijuana on the job. We also saw SB 523, which amends the California discrimination law, known as the Fair Employment Housing Act, to make it unlawful to discriminate against an employee based on their reproductive health decision making. So this is an additional category that gets added to the protected categories under the law. These are, like, for example, your protections for race, sex, gender, all that. So now we're adding reproductive health decision making to the law. And that will conclude the presentation today. If anyone has any questions, I'll be checking in with Annie. But want to thank you all for your time, and it's been a pleasure to be here with you all.
Thank you, Shamara. I don't see any questions in the chat at the moment. We can give the audience a few minutes to see if they have any questions to add in.
Sure.
Okay. We do have a question from Tracy. She wanted to add, a great presentation. Was there a new law that applies to under 5 employees?
Yes. So there is the CalSavers requirement that is going to apply, and you have until December 31st of 2025 to comply with that. You also have the COVID-19 requirements that applies to employers with at least 1 employee. So you need to have either an injury and illness prevention plan or a COVID-19 prevention plan to comply with Cal OSHA's requirements of keeping employees safe. And what other laws did I go through that we had of 1 employee? Obviously, minimum wage, that's going to apply to everybody across the board as well. Trying to think here if I missed any. Let's see. If I missed any. CalSavers. Yeah, I think that was pretty much it for now. And yeah, the pay transparency law, right? So that had requirements for all employers to be able to disclose the pay scale to their current employees. So meaning that you actually need to create a pay scale for the current positions you have in case an employee actually requests that from you. So you can be ready to provide that information to them and maintain the records as required by the law. But those are the ones that are applicable to all employers, even with at least 1 employee.
That employee does not include themselves, correct?
Right, it excludes business owners, yes.
And then I had another question about the cities and minimum wage. Is that 2 hours per week calculated each week? Or is that an average? And let me give you an example.
Mhm.
Let's say I own a roofing company and I get a job in Pasadena and I send a crew there for 3 days. Do those 24 hours count in average across the entire year? Or for that week, do I need to pay them Pasadena minimum wage?
It would be for that week that you would need to pay them the minimum wage, the Pasadena minimum wage.
So every week you calculate that based on where you send your employees.
That's correct. Yes.
Got it. Thank you.
You're welcome. Any other questions?
Thank you, Shamara. Thank you, Lori and Mary. And Annie, of course. Hope you found this helpful, and we will be providing the recording for you.
And I just want to jump in and thank you, Dawn, for spearheading this webinar. And we will have this uploaded to our the learning center of our website soon. So please forward this information. If you know any other employers that would be affected by this, which is just about everybody, it's really important that they get this information as soon as possible. Thanks again.
Thank you all. It's been a pleasure. Have a nice day.